Afẹ́kẹ́ bá wa ṣàlàyé tó ṣẹlẹ̀ nínú kóòtù.
Nǹkan méjì ló ṣẹlẹ̀ láàárọ̀ yìí. Alákọ̀ọ́kọ́ nígbà tá a dé kóòtù tí wọ́n kọ́kọ́ pe kéèsì tí gbogbo wa ta ti announce tí àwọn lawyers ní ẹgbẹ́ mẹ́tẹ̀ẹ̀ta ti announce appearance wa tán. Bí ìgbà tí with apology and without prejudice. Bí ìgbà tí èèyàn mọ tó fẹ́ ṣe.
Don't forget to subscribe, comment, share with your friends to have access to this kind of content that you have here. Don't forget to subscribe. I love and respect you. I'll be right back.
Torí pé wọ́n fẹ́ sọ̀rọ̀ bẹ́ẹ̀lì, wọ́n sì fẹ́ withdraw preliminary objection tí wọ́n file. Torí preliminary objection là ń fà lọ́wọ́ báyìí pé kóòtù yóò lágbára láti gbọ́ sẹ́wọ̀n kí wọ́n ti pe kóòtù náà ní kangaroo tẹ́lẹ̀ náà. So ìwà tí Ọlọ́run sì ní kí lọ́ọ̀ yé àwọn adájọ́ ta wà níwájú wọn. Mo sọ fáwọn èèyàn nígbà tá a jáde lákọ̀ọ́kọ́ yẹn pé nígbà tí èèyàn bá wà ní court of appeal tọ́lọ́n bá ní àbí Supreme Court gan tọ́lọ́n bá ní kí kéèsì ó favour yàn àwọn adájọ́ wọn mọ̀ bọ́ ṣe kéèsì rẹ lọ ìwọ kàn jókòó ni torí lọ́ọ̀yà tó ni wọ́n put to task so àwọn kóòtù gangan ni wọ́n ń béèrè question lọ́wọ́ wọn pé owó lẹ fẹ́ ṣe lọ́dẹ bá sọ wípé lágbára àti gbọ́ lè fi eléyìí lẹ̀ ká wá sọ wípé a lọ sí issue bẹ́ẹ̀lì so kóòtù bá láwọn fún wọn ní ìṣẹ́jú 10 kí wọ́n lọ fi put house wọn in order èwo wọn fi kí wọ́n tún lè wọn tó ṣe ẹ withdraw ní ká proceed àbí ẹ go on pẹ̀lú preliminary objection wọn so nígbà tá a wọlé padà lẹ́lẹ́kejì wọ́n náà ready láti move for objection so objection la wá fà tán nísìn pé ṣé kóòtù lágbára àti gbọ́ àbí kò lágbára ṣé àti abuse process court torí pé ọ̀kan ti wà ní magistrate court àwa sì sọ fún kóòtù yìí pé as far as and ntí lọ́ọ̀ sọ ni pé nǹkan mẹ́ta ló gbọ́dọ̀ pé alákọ̀ọ́kọ́ ni pé ó gbọ́dọ̀ jẹ́ pé kóòtù méjèèjì tẹ́ wà ọ̀rọ̀ kan náà lẹ́jọ́ ń sọ ó gbọ́dọ̀ jẹ́ pé àwọn parties kan náà ni parties sì yàtọ̀ síra wọn àwa sáà argue yẹn àtún fún wọn ní àwọn laws àwọn judgment court of appeal àti Supreme Court tó support àti kóòtù gbogbo alọ́jọ́ yé ní kóòtù bá sọ pé ọ̀dà ní táwọn bá rí sí àwíjàre ọ̀kọ̀ọ̀kan nù wa kí a padà wá níjọ́ Monday tó ń bọ̀ fún àbájáde títí tiwọn.
Good afternoon, sir.
Good afternoon, Mr. Adeoti.
What transpired in court today, please?
Okay.
Òun sọ pé kóòtù ní agbára.
Báwọn bá wá dísà tó bá àwọn lágbára láti gbọ́ àwọn ìṣòwò àwòpé káwọn fún wọn bẹ́ẹ̀lì o àbí káwọn mọ̀ fún wọn.
Ọ̀wọ̀ àwọn lọ́ọ̀yà méjì ó yàtọ̀ síra wọn.
Ẹnì kejì tó dún fẹ́nì kejì ó sọ fún court pé kán dákun ó sọ fún court
Babaláwo tẹ́lẹ̀.
Alhaji ó sọ fún court pé kán dákun fún alábàárà àwọn ní bail ó fún alábàárà àwọn ní bail court wá sọ fún pé wọ́n jọ gbé wọn wá papọ̀ ni kéèsì wọn gbé wọn wá yìí wọ́n challenge jurisdiction of the court pé court ò lágbára láti gbọ́ kéèsì yìí jurisdiction of court sì ní agbọ́dọ̀ determine yẹn kó tó di pa lọ sí case proper wọ́n wá ní táwọn bá decide yẹn tán o kẹ́sì mọ̀ bọ̀ wá àwọn sọ̀rọ̀ wípé káwọn fún wọn bẹ́ẹ̀lì o àbí káwọn fún wọn bẹ́ẹ̀lì èyí tá a wá gbọ́ lónìí ní preliminary objection tí wọ́n gbé wá àti wá gbọ́ wọ́n ti wá fún wọn date wọ́n kì í fòrò lé bóyá káwọn gbọ́ bóyá àwọn ní jurisdiction àbáwọn ní jurisdiction táwọn bá decide yẹn tán decide yẹn tán láti wá lọ sí case bóyá káwọn rí wọn àbí káwọn rí wọn àbí kan strike out matter before the court láìsí.
Fún fàánì ẹ̀yin tí ẹ tún gbọ́ òyìnbó ẹ tún gbọ́ ìbéèrè láti ẹnu bàbá wa US imam tí wọ́n jẹ́ lọ́ọ̀yà fún àwọn mùsùlùmí lóyìnbó tí wọ́n lead ayé tí wọ́n jẹ́ ẹni tó lead àwọn lawyers inshallah lédè òyìnbó yá bismillah.
Good afternoon, sir.
Good afternoon.
First and foremost, can we know your name and who you represent in the case?
Okay. My name is the full name is Umar Saad Imam, and I'm popularly called US Imam even across the globe. I am the lead counsel to the complainant in the case of TaniOlohun, which came up just now.
All right. Can you guys give us a recap, a very brief recap regarding what transpired in court?
Well, two things happened this morning because the court starts 2 times. The first time we entered the court, after the counsel to the both parties have announced their appearance to the court, the lead counsel to the first defendant, which is TaniOlohun, raised the issue of the bail of his clients. And well, in law, I said it to some of my colleagues this morning that when a case is in your favor, the court will continue in doing the case for you. You just sit down because where you made the court that knows the law. So the court took up the counsel that now you have your objection before us, that is before the court. And now that you are talking of the issue of arraignment or bail, what do you want us to do with your preliminary objection? Because the preliminary objection is just like tying the hand of the court, that the court cannot do anything in respect of the case until that issue is finally determined and concluded. So the counsel wouldn't know what to do, with great respect to him, and the court gave them a stand down for 10 minutes to go and put their house in order. So on the resumption for the second time, they decided to proceed with the plenary objection, and the plenary objection has been argued. So the court has adjourned till next week, Monday, 11 September, for ruling whether the court has jurisdiction or not. So it is from there that we are going to know what will happen thereafter. To another court.
Okay, sir.
That is the magistrate court.
Now, can you shed light on, because there was a particular aspect where you were asking court, to award costs and all of that. Can you shed more light on that?
I said because where an application fails, particularly at the higher courts, starting from the High Court to the Court of Appeal up to Supreme Court, even without asking, these courts do award costs. But in this case, the application for costs was just by the way, even though it could go at times. But that is because our conclusion was that the application itself is frivolous and baseless. And therefore, if the court decides to agree with us and strike out the case, then the appropriate thing is to give us cost. Because a lot of time has been wasted and a lot of energy industry has been put in whatever we have filed before the court.
All right, not to preempt the mind of the court anyway,
okay.
But we applicate at the upper area court that same charges at the magistrate's court. Okay. Looking at the face of the law, okay, which one will go for what?
Well, our argument, and if you are, I don't know if you are in court, our argument was that we don't agree on our part, that is as counsel, plural this time, as counsel to the complainants, that the two cases are one. We don't agree to that. And that is our argument. That one, the parties are different. In that of the magistrate's court, the nominal complainant, the main complainant is the Commissioner of Police. While the nominal complainant is the proud sons and daughters of Ilorin Emirate, known as Ogun Ilorin. So the issues, they are not even the same, but they seem to be the same.
The charges?
There is no charges here. Okay. The court corrected the counsel there. That what we have here is just a complaint. We call it a direct complaint, which is allowable in law. So what the mistake some of our colleagues outside the jurisdiction are making is that if you are going into another jurisdiction, you need to study their law. Here, there is a room for direct complaint, particularly here in the north. Going by our Administration of Criminal Justice law of Kwara State 2018, there is a room that is, even the complainant can walk into the court to lodge his complaint. It will be written, the other party would either be or arrested. So either way, once as refers to whether they are the same, we don't agree, and that has been our argument. Then another of our arguments is that if at all there happens to be an abuse of court process, then the first in time would stay, while the second one would have to go. And in this case, we are insisting that this is the first in time, because this was the first to be filed before that one. In fact, there are a lot of there are a lot of games going on with that case. So if the court decides that they are the same, we are urging the court that no, even if they are the same, it is that other one that must go. Now, whether this court has the jurisdiction, the power, the competence, the virus to strike out that case is, I said to the court that it is another ball game entirely, which is true. This court cannot strike out the proceedings before another court.
All right. Lastly, there are some campaigns before now, from members of the society agitating for out-of-court settlement. Okay. Are the councils involved in this case looking towards that direction?
We are not aware. I'm speaking as a council. We are not aware.
But if such is presented to you, will you?
It is allowed. Even the court can raise it. Only that the court should be careful, particularly when there is a very volatile case like this. So if it had been high court, the court might have come out open and clear to advise the parties. We have done it. I've done it with a lot of people here, outside, even outside the state, and we have settled with some of them.
Thank you so much.
Thank you very much, Mr. Adoti.
Alhamdulillah Rabbil Alamin.
This is ODUA TV Watch. Don't forget to subscribe, comment your opinion, like, comment and share, so that other people can get access to what you enjoy on our channel. Thank you. We love you.